This is the Study for the Bar in Your Car podcast.
We're your hosts, Maud and Claude.
And welcome to episode 13, Torts, Negligence, Part 2.
Today, we're really diving deep into a crucial piece, the breach of the duty of care.
Absolutely fundamental stuff. And just a quick reminder for everyone listening, who exactly are we?
Right. Well, we are AI bots.
Yeah, kind of cool.
Brought to life through AI magic, you could say, and probably more importantly, Angela's really detailed negligence notes.
Angela, she's the powerhouse behind this whole operation.
She really is. She's not speaking directly on the podcast today, but she's definitely the brains behind it all.
Yeah, she's busy prepping for the bar exam herself.
Mm-hmm. And she's got quite the background, graduated from the University of Law in the UK.
Right.
And then decided to go to law school again over here in the U.S.
Wow, yeah, George Mason University. That's serious dedication.
Totally. So
Yeah.
her hard work, her notes, that's what makes this podcast possible for you.
So what's the mission for you, our listener, today?
Well, we're aiming for a really focused exploration of what breach of duty actually means in negligence claims.
Starting with the basics, the definitions.
Exactly. And building up to how it works in, real life practical application.
We really want to make these sometimes kind of dense legal ideas more digestible.
Yeah, really useful for your bar prep. So you don't just memorize, you actually get it.
That's the goal. And hey, if you have feedback for Angela about the podcast.
Oh, yeah, definitely let her know. You can email her at podcast@studyforthebarinyourcar.com.
And there's more. Angela also works as a freelance law clerk.
That's right. So if you happen to be an attorney, or maybe you know one,
Uh-huh.
and they need some ad hoc help, like research or writing motions, complaints, writs, answers, briefs, that kind of thing.
Okay.
Angela does that. You can reach her for those services at a different email, hello@legalwriterandlawclerk.com.
Good to know. All right, let's get into the heart of it. Defining breach of duty.
Okay, breach of duty. It's where the rubber meets the road in a negligence claim, really.
So how do Angela's notes actually define it? What's the core legal idea?
The definition is pretty clear. A defendant has breached their duty when their conduct falls short of that level required by the applicable standard of care owed to the plaintiff.
Falls short. So basically they didn't do what they were supposed to do care-wise.
Exactly. Did their actions, or maybe their lack of action, fail to meet that expected standard?
And who decides if they fell short? Is that a judge thing?
Generally, no. This is super important, and Angela's outlines stress it. Whether the duty of care is breached in an individual case is a question for the trier of fact.
Trier of fact. So usually the jury.
Usually the jury, yeah. They're the ones who listen to everything and decide if the defendant actually messed up based on the standard.
Why the jury? What's their specific role here?
Well, as cases like Foltz versus Cerdelli's America Inc. show, the jury's job is to weigh all the evidence, especially when it's contradictory. They have to figure out who to believe, judge witness credibility, and then draw conclusions about what actually happened. It's very fact-heavy.
So the judge usually keeps their hands off the breach question?
Pretty much. The decision only really becomes one for the judge when reasonable minds could not differ about what conclusion could be drawn from the evidence.
Okay. So if it's so obvious that everyone would have to agree, then the judge might step in.
Exactly. It's a really high bar. It shows how much weight the system gives to the jury's role in sorting out the facts.
That makes sense. If the jury's judging credibility, how do they even do that? It sounds kind of subjective.
It does. But there are guidelines. The courts provide pattern jury instructions.
Right.
And these instructions, drawing from cases like Upchurch, tell jurors to look at various factors. Things like, the witness's demeanor on the stand.
Like how they act. Nervous, confident.
Yeah, exactly. How they present themselves. But also, is their story consistent? Does other evidence back it up? Do they seem biased? How good is their memory?
So it's the whole picture, not just the words they say.
Definitely. It's how they say it and how it fits with everything else the jury has heard.
And this whole credibility thing, it can get tricky, right? Like with directed verdicts.
Oh, absolutely. Take the case of Dawn versus Librowitz.
The pedestrian hit by a truck?
That's the one. Her testimony wasn't directly contradicted by other evidence.
Okay. So you'd think, case closed, directed verdict for her.
You might think so. But the court said no. Even though her story was uncontradicted, her credibility, whether the jury actually believed her, was still for the jury to decide.
Wow. So even if no one says she's lying, the jury can still decide, they just don't buy it.
Precisely. It really shows how central the jury is to judging believability. Now, that said, some courts are a bit different.
Oh.
Yeah, Angela's notes mention C. Trevino versus Kent County, where some courts might allow a directed verdict if the testimony is not just uncontradicted, but also really clear and self-consistent.
So if it's super straightforward and consistent, maybe the judge can step in. It's not totally uniform.
Right. It's a bit of a split, balancing jury power and judicial efficiency.
Okay. What about expert witnesses? Is their testimony treated differently? I remember Wald versus Granger.
Good pull, yes. Expert testimony can be different. In Wald, the court suggested a jury isn't just free to ignore undisputed expert testimony on something like a permanent injury.
So if all the experts agree on a medical fact, the jury can't just decide, nah, we don't think so.
Pretty much. If qualified experts on both sides agree on a specific technical point, that fact is generally taken as established. The jury's role isn't to second-guess unanimous expert consensus on specialized knowledge.
That makes sense. And this links to judges deciding whether to grant new trials, too, right? Like in Dillon versus Frazier.
Exactly. In Dillon, liability was admitted, the damages were basically undisputed, but the jury awarded way less.
Uh-oh.
Yeah. The trial judge didn't grant a new trial, but the appellate court said that was an abuse of discretion. If the damages are clear and liability isn't contested, the jury can't just ignore the evidence.
So they have to follow the undisputed facts. Same idea in Forsythe versus Joseph, the car hit by the truck.
Same principle applies, yeah. If damages are proven and not really contested, the jury's job is to award them, not disregard them. They find facts, but within the bounds of the evidence.
Okay, so we've got duty, we've got the jury figuring out breach based on credibility and evidence. How does breach fit into the overall negligence claim structure? It's not the end of the story, right?
Not at all. It's a crucial link, but just one link. Once you establish the defendant owed a duty, step one, then you ask, did their actions or lack of action fail to meet that standard? That's the breach inquiry.
Okay.
And this failure isn't just any mistake. Angela's notes highlight it has to involve unreasonable conduct and creating a foreseeable risk of harm.
Unreasonable conduct, foreseeable risk. Key phrases. So how do we judge unreasonable? Is there a standard?
There is. It's maybe the most famous standard in tort law. The reasonable person.
Yeah, the reasonable person. Heard of them.
Right. The default standard is, essentially, what would a reasonably prudent person of ordinary sensibilities have done under like circumstances, as measured by an objective standard?
Objective. So it's not about what this defendant thought was okay?
Nope. Not subjective at all. We don't care what was going on in their head. We compare their actions to this external, objective benchmark of a sensible, careful person in the exact same situation.
Got it. It's an external measuring stick. So you compare the defendant's actions to what this imaginary reasonable person would have done.
Precisely. Do they fall short? That's the breach analysis in a nutshell.
But sometimes it feels more complex than just what would a reasonable person do. Is there a more analytical way?
Yes. Especially for complex situations, we often turn to the learned hand test.
Learned hand. Sounds distinguished. Is it like a formula?
It kind of is. It's often expressed as BPL. It balances the probability and gravity of harm against the burden of precautions.
B less than P times L. Okay, break that down. What are B, P, and L?
Okay, B is the burden of taking adequate precautions. Like how much would it cost or how difficult would it be to prevent the harm?
Okay, burden. Got it.
P is the probability of the harm actually happening if you don't take precautions. How likely is the bad outcome?
Probability. Makes sense.
And L is the gravity of the resulting harm. Some sources say loss, but gravity is common. Basically, how severe is the injury or damage if it does happen?
Burden, probability, gravity. BPL.
So if the burden B is less than the probability, P times the gravity L,
then the defendant's failure to take those precautions, that's negligence. That's the breach.
So if it's relatively easy or cheap, low B, to prevent a likely high P and severe high L harm, and you don't do it, you've breached your duty.
You nailed it. It's a very logical, almost economic way to think about reasonableness.
Seems practical. Is there anything else factored into that learned hand equation?
Yes, a really important one. The social utility of the conduct.
Social utility, like how valuable is the defendant's activity to society? Exactly. Think about an emergency vehicle, like an ambulance, speeding.
Okay.
The probability of an accident, P, might be higher, and the gravity of harm, L, if one happens, is serious.
Definitely.
But the social utility, saving a life, getting someone urgent care, is incredibly high. So the burden B of forcing them to always drive slowly might be deemed too great compared to that benefit.
Ah, I see. So the usefulness of the action itself gets weighed in. It's not just about the isolated risk.
Right. It prevents the law from chilling beneficial activities by demanding unrealistic levels of caution. Compare that ambulance to someone just joyriding recklessly, zero social utility there.
That makes a lot of sense. It adds nuance. Okay, shifting gears a bit. What if a company has its own internal safety rules, like in a manual? If an employee breaks that internal rule, does that automatically mean the company was legally negligent?
That's a super common question, and the answer is generally no.
No, even if their own manual says do X and the employee did Y.
Even then, Angela's notes and case law are pretty clear. A defendant's internal rules or manuals don't automatically set a higher legal standard of care for negligence purposes.
Why not? Seems counterintuitive.
The thinking is, if companies knew their internal, often aspirational, safety goals would become legally binding minimums, they might be discouraged from setting high internal standards in the first place. They might just write manuals that only cover the bare legal minimum to avoid extra liability.
Ah, okay. So not making internal rules legally binding actually encourages companies to aim higher internally without fear of it being used against them quite so easily in court.
Exactly. It fosters best practices without penalizing companies for striving beyond the legal floor.
What does something like the Restatement of Torts say about this?
The Restatement, third, Part 13, takes a balanced view. It says that departing from an internal standard does not set a higher standard of care for the actor.
Okay, so it doesn't set the standard.
Yeah.
But is it completely irrelevant?
Not completely. It can be relevant evidence. For example, it might help show that the company knew about the risk, foreseeability, or that taking precautions was possible, feasibility.
Yeah.
Or maybe even that the plaintiff reasonably relied on the company following its own rules.
So it's evidence the jury can consider, but it doesn't automatically equal breach.
Precisely. It's a piece of the puzzle, not the whole picture.
Can you give an example from a case?
Sure. Think about Morgan v. Scott. A car dealership had an internal rule. Employees must accompany test drivers.
Okay.
An employee didn't. The test driver caused an accident, injuring someone else. The court said the internal rule didn't create a legal duty to the injured third party.
So the internal rule was for the dealership's benefit, not necessarily a legal promise to the public.
Kinda, yeah. And similarly, in Everett versus General Electric Company, an internal policy about impaired employees didn't create a specific legal duty to the public either. It consistently shows internal policies don't automatically become external legal duties.
Got it. Internal rules are one thing. What about industry custom? If everyone in a trade does something a certain way for safety, does that set the standard of care?
Yes, custom is a very different story. It can be incredibly important.
How so?
Angela's notes say, proof of a general custom and usage is admissible because it tends to establish a standard by which ordinary care may be judged.
Okay, so what's common practice in an industry can show what's considered reasonable care within that industry.
Exactly. It reflects the collective judgment and experience of those in the field about what's safe or necessary. It's strong evidence of the standard of care.
Does custom still matter if there's already like a law or a building code setting a minimum standard?
It absolutely can. Custom can be relevant even where an ordinance prescribes certain minimum safety requirements which the custom exceeds.
So just meeting the bare minimum required by law might not be enough if the industry custom is to do more?
Correct. The law often sets the floor, but custom might set a higher bar for what's considered ordinarily careful.
Interesting. Is there a case example for that?
Yeah, Duncan Veda, 1991 is a good one. Plaintiff injured by a collapsing wooden stairway.
Okay.
The building code might have technically allowed non-pressure treated lumber, but the plaintiff wanted to introduce expert testimony that the custom in construction was to use pressure-treated lumber for outdoor stairs.
Because it lasts longer. Safer.
Right. The court said that evidence of custom should have been allowed, even if the code didn't mandate it. It showed what reasonable builders actually did to ensure safety, potentially setting a standard higher than the minimum code.
Wow, so custom can effectively raise the standard of care beyond just following the law. That's powerful. Okay, now, what if you just can't find direct evidence of what the defendant did wrong? Like, an accident happens, it seems like negligence, but there are no witnesses, no clear proof of the specific careless act.
Now you're getting into a really interesting doctrine.
Yeah.
Res ipsa loquitur.
Res ipsa loquitur.
Yep.
Latin, right?
Yep. Means the thing speaks for itself.
The thing speaks for itself. Catchy. What does it do?
It's a rule of evidence, really. It allows a jury to infer negligence based purely on the circumstances of the accident, even without direct proof of the defendant's specific failure.
So the accident itself suggests somebody must have been careless.
Pretty much.
Yeah.
It applies when the situation strongly implies negligence was involved, and it likely points towards the defendant.
Okay, but it can't apply to just any unexplained accident, right? What are the conditions?
No, definitely not any accident. There are specific requirements, generally 3. First, the event has to be the kind that ordinarily doesn't happen unless someone was negligent.
Like a surgical tool left inside a patient.
Classic example.
Mm.
Second, the thing that caused the injury, the instrumentality, must have been within the defendant's exclusive control.
Exclusive control. And third?
Third, the injury must not have been due to any voluntary action or contribution by the plaintiff. They didn't cause it themselves.
Okay, so doesn't usually happen without negligence. Defendant had exclusive control. Plaintiff didn't contribute. And crucially, Angela's notes add, the evidence must suggest negligence was probably that of the defendant.
Exactly. It has to point fingers probabilistically at the defendant. Think about Savage versus Three Rivers Medical Center, 2012.
What happened there?
A sponge was left in a patient. Seems like classic res ipsa.
Yeah.
But the patient had 3 different surgeries there with different teams. They couldn't say which surgery, which team was responsible.
So the negligence wasn't clearly traceable to one defendant or act. It failed probably the defendant part.
Precisely. It shows the doctrine needs some specificity.
What about that exclusive control element? I feel like that could be tricky. How strictly is it applied?
Historically. Very strictly, sometimes ridiculously so.
Like how?
Angela's notes mention Kilgore versus Shepard Co. 1932. Plaintiff sits in a store chair, it collapses.
Ouch. Seems like res ipsa. The store controls the chair's maintenance.
You'd think. But the court rejected res ipsa, arguing that because the plaintiff was sitting on the chair, she was in control at that moment.
Seriously, that seems overly technical. That would rule out res ipsa for almost anything a customer uses.
Right. It was a very literal interpretation. Thankfully, that's mostly changed.
Okay, good. So how does it work now? More flexible.
Much more flexible and sensible now. Courts readily apply res ipsa in cases involving things like collapsing chairs, bar stools, bleachers, like in Trujek versus Service Merch Cow, 1994.
So they look beyond who is touching it at that second.
Yeah, they focus more on whether the defendant had the overall responsibility for the safety and maintenance of the thing that caused the harm. The underlying defect is usually within their sphere of control, even if the plaintiff was using it.
That makes way more sense. What about something more complex, like a vehicle accident? Say a bus just veers off a dry road, like in Aldana versus School City v. Chicago 2002. Could the bus company argue the road wasn't in their control?
They could certainly try that argument. They might say, hey, maybe there was a pothole we couldn't control.
Right.
But a court today would likely focus on the driver's control over the vehicle. Buses generally don't just swerve off dry roads without some issue related to the vehicle's operation or maintenance, speeding, distraction, mechanical failure. Things arguably within the defendant's control or responsibility.
So the court looks at what's the most probable explanation related to the defendant's control.
Exactly. Does the type of accident point more strongly towards negligence by the party controlling the main injury-causing agency?
Okay, but what about things the public uses all the time, like escalators? In Ebanks versus New York City Transit Authority, didn't they still use that strict control rule?
Some jurisdictions, like New York and Ebanks, do still cling to a stricter version, yeah. They argue that public access means control isn't truly exclusive, so res ipsa fails if, say, an escalator suddenly jolts.
But other places are more liberal.
Oh, yeah. Think about the exploding bottle cases. A bottle explodes off the shelf. How can the plaintiff prove the bottler had exclusive control after it left the factory?
Right. It passed through distributors, retailers.
Exactly. So the more liberal approach allows the plaintiff to use res ipsa by basically ruling out other causes. If the plaintiff and retailer handled it properly, the inference points back to a defect originating with the defendant bottler. It shifts the burden of explanation.
That seems much fairer in those kinds of situations. Okay, so res ipsa lets the jury infer negligence. How does that compare legally to negligence per se? That sounds more definitive.
It is way more definitive. This is a critical distinction. Res ipsa, even if it applies, as Angela's notes say, just goes to the weight of the evidence.
Meaning
the jury can infer negligence, but they don't have to. It's permissive. They weigh the inference along with everything else. They might still decide there wasn't a breach.
Okay, so res ipsa is like, hey, jury, you can find negligence here if you think the circumstances warrant it.
Exactly. It's a may-find situation.
Whereas negligence per se.
Negligence per se is totally different. If it applies, breach of duty is established as a matter of law.
As a matter of law. So the jury doesn't even decide breach.
Correct. If the conditions for negligence per se are met, the court basically says, okay, the defendant violated a statute meant to prevent this type of harm to this type of person. That is the breach. It replaces the flexible, reasonable person standard with the rigid standard set by the statute.
Wow, that's a huge shortcut for the plaintiff.
Wow.
What are those strict conditions then?
Got to meet all three. 1, the defendant clearly violated a statute.
Okay, broke a law.
2, the plaintiff has to be in the class of people meant to be protected by the statute. The law was aimed at protecting people like them.
Right, not just anyone.
And 3, the plaintiff suffered the type of harm that the statute was designed to protect against. The injury has to match the purpose of the law.
Class of person, type of harm. Got it. Can you give a concrete example?
Angela's notes have a great one. Landlord fails to maintain a working fire escape, violating a safety code. Tenant gets trapped in a fire, suffers burns, and smoke inhalation.
Terrible. Does that fit negligence per se?
Perfectly. 1, landlord violated the statute. No working fire escape. 2, tenant is definitely in the class protected by fire safety codes. 3, burns and smoke inhalation are exactly the type of harm fire escapes are designed to prevent.
So in that case,
Angela's notes say, duty and breach as elements are satisfied, as a matter of law. The jury doesn't debate if the landlord was unreasonable about the fire escape. The statute sets the standard, and violating it is the breach.
So the jury's just told duty and breach are established here.
Pretty much. The jury will be required to find, okay, we have duty and breach. The plaintiff still has to prove causation, that the lack of the fire escape actually caused or worsened their injuries and proved their damages. But duty and breach are locked in.
That's incredibly powerful. It really shows how laws can directly shape tort liability. Okay, let's shift again. What about situations where someone could help but doesn't? Is there a general duty to rescue someone in danger?
This is a big one, and the general rule often surprises people.
Which is?
Generally, no, as Angela's notes state very clearly. Generally, one does not have a legal duty to act. There is no duty to rescue.
No duty to rescue, even if it would be easy and safe to help.
Even then, generally speaking, the law traditionally prioritizes individual liberty over imposing affirmative duties onto strangers. Morally, we might feel obligated, but legally, you usually don't have to intervene unless an exception applies.
Okay, so the default is no duty. What are the big exceptions where a duty does arise?
There are several key ones. First, if there's a special relationship between parties.
Like what kind of relationship?
Think common carriers and passengers, airlines, buses, innkeepers and guests, employers and employees on the job. Sometimes doctors and patients, though that gets specific.
How specific for doctors?
Well, Rule 1688 in the notes mentions a doctor's duty is usually just to the patient, unless the patient poses a clear, foreseeable threat to an identifiable third party that the doctor could reasonably warn or protect against.
Okay, so special relationships create a duty. What's another exception?
Second, if the peril is due to your own conduct.
Meaning, if you cause the danger.
Exactly. Even if your conduct wasn't negligent itself, if your actions put someone else in peril, you now have a duty to provide reasonable assistance. Like if you accidentally knock someone over, even if you were being careful.
Because you created the situation. Makes sense. Third exception.
Assumption of duty by acting. If you voluntarily start to help someone, even if you didn't have to, you then take on a duty to act reasonably and not leave them worse off than they were before you intervened.
Yeah.
You can't start CPR and then just wander off halfway through if it makes things worse.
Okay, once you start, you're committed to being careful. What about harm caused by other people? Is there ever a duty to prevent harm from third persons?
Generally, no liability for the torts or crimes of others because those acts usually break the causal chain. But there's a big exception. Rule 1687 notes that if the third-party tortious or criminal acts were foreseeable by the tortfeasor, then the original negligent person might still be liable.
Foreseeable third-party acts, like what?
Maybe a landlord failing to fix broken locks in a high-crime area and a tenant gets assaulted. The crime was arguably foreseeable due to the negligence. Or a bar over-serving someone who then foreseeably causes a drunk driving accident. The third party's act doesn't automatically sever liability if it was a foreseeable consequence of the initial negligence.
Got it. Foreseeability is key there, too. Okay, so we've thoroughly covered breach, but just proving breach isn't enough to win, right? What comes next?
Absolutely not enough. Breach is step 2, maybe. After establishing duty, step 1, and breach, step 2, the plaintiff must prove causation.
Causation, the link between the breach and the harm.
Exactly. Both factual cause and legal cause, or proximate cause. And then finally, they have to prove damages. Without causation and damages, even a clear breach means no recovery.
Let's tackle factual causation first. That's the but-for test, usually.
That's the main one, yeah. The but-for test asks whether the plaintiff's injury would have happened but for the defendant's act.
So if you could magically remove the defendant's negligent act from history, would the injury still have occurred?
That's the idea. If the answer is no, the injury would not have happened without the defendant's act, then, as Angela's notes say, the defendant's conduct is cause in fact of the plaintiff's injury.
It's an essential link in the chain of events.
Precisely. And importantly, the defendant's act doesn't need to be the only cause.
Right, just a cause.
Correct. It is not necessary that the defendant's act be the sole cause, only that it be a cause. Real-world injuries often have multiple contributing factors.
Can we walk through an example, maybe one where the link isn't super obvious?
Sure, the Miss Hale case from the notes is perfect. Remember her? Overgrown bushes on the sidewalk?
Yeah, forced her into the street.
Right. So she steps into the street, looks up at traffic, and while looking up, she trips on a broken piece of sidewalk and gets injured.
So the bushes didn't trip her. The broken sidewalk did. How are the bushes a but-for cause?
Because of her deposition statement. She said, essentially, but for the bushes blocking the sidewalk, I wouldn't have needed to step into the street and therefore wouldn't have looked up for traffic at that exact moment and wouldn't have tripped.
Ah, the bushes put her in the specific position and state of mind that led directly to the trip over the defect.
Exactly. It created a genuine issue of material fact for the jury. Maybe she would have tripped anyway, maybe not. But because the bushes arguably changed her path and focus, a jury could find they were a but-for cause of her falling, where and when she did. Causation, the court said, is for the jury.
That really shows how indirect factors can still be factual causes.
Yeah.
Okay, what about when you have multiple defendants, multiple potential causes? How does the law sort that out?
It gets complicated. The law first tries to determine if the injuries are divisible or indivisible.
Divisible versus indivisible. Let's start with divisible. What does that mean?
Divisible injuries are basically separate harms caused by different actors. Like, defendant A breaks your arm, and later, totally unrelated, defendant B breaks your leg.
Okay, two distinct injuries.
Right. In that case, liability can be apportioned by causation. A pays for the arm, B pays for the leg. Each is only liable for the specific harm they caused.
Makes sense. But what if their actions combine to cause one single inseparable injury that's indivisible?
Exactly. That's an indivisible injury. Imagine defendant A negligently leaves something dangerous in the road, and defendant B negligently hits it, causing a single set of severe injuries to a passenger.
You can't really say A caused this bruise and B caused that fracture if it all happened at once.
Precisely. Both A's act and B's act could be but-for causes of the single unified harm. Since you can't split the injury logically, both are subject to liability for the whole thing.
Both on the hook for the whole injury.
Potentially, yes. Think about C-SPAN versus Shaquille Lumber Company. Lumber Company's negligence caused dense fog.
Right, and other drivers were also negligent.
Leading to a big pileup. The court found the lumber company's fog was a factual cause of the indivisible collision damage, along with the other driver's negligence. This leads us straight to joint and several liability.
Ah, joint and several. That sounds serious. How does that work?
It's a big deal, especially for plaintiffs. Rule 1764 explains it. When multiple tortfeasors act independently, but their actions combine as substantial factors, causing an indivisible injury, they are jointly and severally liable for the plaintiff's entire loss, unless the defendants can somehow prove the harm is divisible.
Jointly and severally, meaning?
Meaning the plaintiff can recover the full amount of their damages from any one of the liable defendants.
Wow. So if they get a $1 million judgment against two defendants, they can collect the whole million from just defendant A.
Yes. Then it's up to defendant A to try and get contribution, the fair share, from defendant B. It shifts the risk of one defendant being unable to pay from the injured plaintiff to the other wrongdoers.
Huge advantage for the plaintiff. Now, sometimes that but-for test feels clunky, especially if two different things could each have caused the harm on their own. Is there another test?
Yes, for those situations, particularly with multiple sufficient causes, courts often use the substantial factor test.
Substantial factor. Does the defendant's negligence need to be a substantial factor in causing the harm?
Pretty much. Even if it wasn't strictly necessary in a but-for sense, because something else also would have caused it, was it a major contributor? The restatement, third, section 36, also notes a flip side. If the contribution was merely trivial.
Trivial, like insignificant.
Right. Then it's not considered a cause within the scope of liability. Think about asbestos exposure. 40 years from defendant A versus one single day from defendant B. That single day might be deemed trivial.
Or throwing a match on an already raging forest fire.
Perfect example. The test filters out truly minor contributions and focuses on whether the defendant's act played a meaningful role in the outcome.
Okay. What about situations where the negligence is basically failing to provide a safety measure, like no lifeguard and someone drowns? Then causation seems tricky there.
It is tricky because the plaintiff might have drowned even with a lifeguard, or someone might have fallen on perfectly built stairs. It's hard to prove, but for the lack of the lifeguard, they definitely would have survived.
So how do courts handle that?
They often permit juries to find that the defendant's negligent acts or omission was a factual cause. The reasoning is that the defendant's negligence created or increased the very risk that then happened. Failing to provide the expected safety measure is seen as causally linked when that specific danger materializes.
The failure to protect is the cause, in a sense.
In a sense, yes. It deprived the plaintiff of a chance of avoiding the harm, and this connects directly to loss of chance claims.
Right, mostly in med mal, where maybe the doctor's mistake didn't definitely cause death, but reduced the chance of survival.
Exactly.
Yeah.
Some jurisdictions allow recovery for that lost chance itself. Rule 1765 in the Moore case example. If a patient had a 40% chance of survival, and the doctor's negligence, more likely than not, eliminated that chance, the doctor could be liable for that lost 40% chance. So maybe 40% of the total damages that would apply if they had caused the death. It's proportional recovery for the lost opportunity.
That's a major shift from needing to prove the negligence caused the ultimate bad outcome. Is the standard of proof still high?
Oh, yes. The plaintiff still has to prove by a preponderance of the evidence that the negligence caused the loss of chance. It wasn't automatic in Almonte v. Curl 2012. They couldn't prove the ER doc's negligence actually caused the suicide or the lost chance of a better outcome. You need solid evidence, usually expert testimony.
And do courts care how big the lost chance was? Does a 5% lost chance count, or does it have to be substantial?
That's debated. Some courts do require the lost chance to be substantial. They worry about too many lawsuits over tiny percentage changes. But other courts, like in Alexander v. Shai 2000, reject that. They argue basic economics will deter suits over truly trivial losses anyway. Who's going to pay lawyers to sue over a 1% lost chance? So they don't see a need for a legal substantiality threshold.
Interesting practical argument there. Okay, let's pivot now and apply all this duty, breach, causation to a really high-profile, tragic case, the Vanessa Bryant lawsuit.
Right. The Vanessa Bryant case is just a devastatingly clear example of breach of duty and the resulting harm, invasion of privacy, emotional distress. It stems from that horrific helicopter crash in January 2020.
Kobe Bryant, his daughter Gianna, and others. Such a tragedy. Who sued whom in that lawsuit?
Vanessa Bryant, Kobe's widow, and also Chris Chester, who lost his wife and daughter in the same crash, sued the Los Angeles County Sheriff's and Fire Departments.
Okay, suing the county departments. What was the core allegation? Not about the crash itself.
Correct. It was entirely about the aftermath. Angela's notes specify they alleged invasion of privacy and emotional distress from unauthorized sharing of crash site photos of their deceased loved ones.
Unauthorized photos. What exactly were the county employees alleged to have done wrong? What was the breach?
The allegations were truly shocking. Sheriffs and fire department personnel allegedly took and disseminated graphic photographs of the crash site using their personal smartphones.
Personal phones,
Yeah.
not official cameras for investigation.
Exactly. And the details from the source material, Bryant.pdf, are grim. One deputy took maybe 25 to 100 photos, many of which had no conceivable investigatory purpose and were focused directly on the victim's remains.
Oh my God. That's horrific. And they shared these photos.
Yes. They quickly spread within the sheriff's department as deputies transmitted them to one another via text message and airdrop. One deputy shared them with another deputy who had absolutely no role in investigating the accident.
Just casually sharing photos of human remains. And didn't some photos get shown to the public?
That was the most appalling part. That second deputy, Deputy Cruz, was at a bar and allegedly showed the photos to a bartender.
At a bar?
Yes. And then reportedly, loudly boasted that he had just seen a photo of Kobe Bryant's body and described the image in graphic detail. It moved from internal misconduct to public spectacle.
Unbelievable. So taking and sharing those photos, especially publicly, that's the breach of duty.
Absolutely. The lawsuit stated clearly, multiple members breached their duties by taking and/or sharing photos for personal, non-law enforcement purposes. First responders have a profound duty of care and respect in such situations, especially regarding victims' remains. That duty was completely shattered.
And foreseeability. Did they argue the deputy should have known this would cause harm?
Definitely. The complaint argued these members foresaw or should have foreseen that their conduct would injure plaintiff. Plus, adding insult to injury, there were allegations of deleting the photos from phones after complaints surfaced trying to destroy evidence.
Just awful. So the harm claimed was invasion of privacy and what else?
Severe emotional distress. The invasion of privacy claim was based on public disclosure of private facts.
Right, publicizing private, offensive facts, not of legitimate public concern. These photos certainly seem to fit that.
Perfectly. And then there was intentional infliction of emotional distress, IED.
IAD, that requires extreme and outrageous conduct, right?
Yes, plus intent or recklessness regarding the distress, causation, and severe distress. The plaintiffs argued taking and sharing photos of deceased loved ones for shock value or personal kicks was absolutely extreme and outrageous, far beyond all bounds of decency.
It sounds similar in principle to the Hulk Hogan case, Bully v. Gawker, where publishing the tape is found outrageous.
Very similar. In Bolia, Gawker tried a First Amendment public concern defense. Here, the jury verdict strongly suggests there was no conceivable legitimate public concern defense for sharing graphic crash scene photos. Morbid curiosity isn't a legal defense.
And the severe emotional distress element.
That was central. The plaintiffs claimed severe and continuing emotional distress. Angela's notes mention some places allow IAD recovery without physical symptoms if the distress is otherwise proven severe. And the testimony in this case undoubtedly conveyed that level of anguish.
So what was the final verdict? What did the jury decide?
The jury found in favor of Vanessa Bryant and Chris Chester. They awarded them a combined $31 million.
$31 million, wow.
Yeah. $15 million for Vanessa Bryant, $16 million for Chris Chester. It was a massive statement about the severity of the breach, the outrageousness of the conduct, and the profound harm caused. It underscored that such violations of dignity and privacy by public servants carry enormous consequences.
An incredibly powerful real-world example of breach and its consequences. Okay, we are going to start wrapping up this podcast now.
But first, a huge thank you, truly, to Angela for her amazing torts notes. Her work in putting all this complex material together is what lets us have these discussions.
Absolutely. And listeners, just those friendly reminders we always give. Angela, she's a student, just like many of you, studying hard.
Right. She's not an expert yet, hasn't passed the bar. So, crucially, nothing we say here and nothing Angela writes is legal advice.
Please don't construe it that way. This isn't legal advice for your situation.
And remember, AI, like us, well, we're a tool. This podcast should supplement your studies, definitely not replace them.
Yeah, don't rely solely on us, and AI isn't perfect.
Nope. Sometimes we might make mistakes.
Yeah.
Angela does her best to catch and fix things in the notes, but always double check against your primary sources.
And finally, for everyone listening, especially if you're driving, be safe.
Yes, safety first. Don't cause a tort while listening to torts.
Good one. Okay, if you need to reach Angela about the podcast, the email is podcast@studyforthebarinyourcar.com.
And for attorneys needing freelance law clerk, help research writing motions, complaints, answers, briefs, etc. That's hello@legalwriterandlawclerk.com.
Got it. Okay, before we officially sign off, tradition dictates. A cheesy lawyer joke. You got one about duty of care?
I think I do. Why did the law student bring a map to the torts exam?
A map to the torts exam. I don't know why.
Because they heard they needed to establish the proper metes and bounds of the duty of care.
Oh boy, that's definitely cheesy. Okay then, this is Maud.
And I'm Claude, your AI bot signing off.
Thanks so much for listening. Bye.
Bye, everyone.
And just one final thought to leave you with as you ponder breach of duty. Think about how emerging technologies, AI decision-making, autonomous systems, genetic editing are blurring the lines of foreseeability and control. How will our existing tort law principles, built around human actors and predictable mechanics, adapt to assign responsibility when harm arises from complex, opaque algorithms or unforeseen biological interactions? Are we equipped to define the reasonable algorithm or the duty of care in contexts that barely resemble the world where these doctrines were born? Something to consider as the future unfolds.